Thank you, Chairman, members of the committee. House Bill 2818 provides review guidelines and evaluation criteria for the legislature to review and consider bills introduced after July 1st, 2024 that propose regulation of occupations or professions not regulated prior to July 1st, 2024. In addition, the bill provides for a review process and reports by agencies through the Joint Committee on Administrative Rules and Regulations to provide information to the legislature regarding bills that increase current regulation of occupations and professions. So, turning to the bill, Section 1 sets forth the intent of the legislature with respect to the bill, and you can see that on page 1 of the bill. There are two subsections that describe that intent and also the purpose of the act. Section 2 sets out definitions in the bill. Section 2 starts there on page 1 and then continues until page 3. And Section 3 gets to the heart of the bill. That's on page 3. It describes the legislative review process for bills proposing to newly regulate an occupation. The bill states that an occupation not previously regulated shall not be regulated by the state unless the legislature determines that unregulated practice could cause recognizable and significant harm and endangerment to the general welfare. The public would benefit significantly from an assurance of personal qualifications, and that the general welfare cannot be sufficiently protected by any other means. And you can see those guidelines set out there at page 3, in the middle of the page, lines 26 through 32. After considering those criteria, and also governmental, economic, and societal costs and benefits, the bill provides that if the legislature determines that the state has a strong interest in regulation of the occupation, the legislature shall implement the most efficient form of regulation consistent with protection of the general welfare pursuant to the guidelines set forth in subsection B1 through 3 with respect to the type of regulation to be implemented. And those guidelines discuss the criteria for implementing regulation by insurance, bonding, or registration, a system of certification, or if these methods are insufficient to protect the general welfare from recognizable harm, a licensing regime. And you can see those criteria at the bottom of page 3 and the top of page 4 of the bill. They discuss the threat to general welfare, if the consumer has challenges accessing credentialing information or possesses less information that puts the consumer at a disadvantaged position in relation to the practitioner, and if other regulatory structures are insufficient to protect the general welfare from recognizable harm. In that case, then, the bill states that the regulation shall implement a system of licensing. And with respect to that, I might refer you back to the definition section on page 10. You'll see that there's a definition of least restrictive type of occupational regulation there in subsection D. And the bill sort of sets out these types of regulations from least to most restrictive, starting with bonding or insurance, and then all the way to licensure. Section 4 at page 4 provides for a process of review of introduced bills pertaining to regulation of an occupation by the Joint Committee on Administrative Rules and Regulations. Bills are not required to be referred to the Joint Committee for this review. If the Joint Committee determines that the introduced bill proposes stronger or additional regulation of an occupation that is currently regulated by this state, or regulation of an occupation that is not currently regulated by Kansas, the Joint Committee is to notify the relevant regulatory body of the bill that it has been introduced. The regulatory body then has 10 business days after that notification to prepare and submit a report in electronic format to the Joint Committee, the chairperson, vice chairperson, and ranking minority member of the committee to which the bill has been assigned, the Speaker of the House, Minority Leader of the House, President of the Senate, and Minority Leader of the Senate. The bill specifies the information that is to be contained in that report at pages 4 to 6, and that is a significant amount of information. You can go through that on pages 4, 5, and 6 of the bill. One item that I might point out is that the regulatory body is to provide information with respect to potential harm pertaining to complaints that have been made to state law enforcement or courts or agencies or professional occupational boards, and provide that information redacted as necessary, even though it may be confidential, to provide that information redacted as necessary. And that provision is on the top of page 5 of the bill. Subsection C at page 6 sort of provides a plan B for this report, and that is if the Joint Committee determines that the bill proposes new regulation of an occupation that is not regulated by Kansas, and also determines that no Kansas regulatory body has the expertise to regulate that occupation. In that case, the Joint Committee can contract with a professional consultant, professional in the field, perhaps professional faculty at a Kansas institution of higher learning to prepare a report. This report is also required to be produced within 10 business days. The Director of Legislative Services is to secure, prepare, and administer the contract, and the contract must be approved by the chairperson or vice chairperson of the Legislative Coordinating Council. And that approval is authorized while the legislature is in session. This report is, again, to be provided electronically to the same persons with respect to the report we previously discussed, and in addition to any regulatory body that discussed or participated in preparing the report. And then this report contains slightly different information that's set out in subsection C 1 through 5, and that's on pages 6 to 7. So you can see the information that's laid out in detail that is required by the report on pages 6 and 7 of the bill. With respect to both types of reports, all state agencies are directed to cooperate with the regulatory body or contracted party engaged in preparation of the report. There is an exception in this bill with respect to regulation or credentialing of any occupation subject to the provisions of the Kansas Act on credentialing. And these occupations broadly include healthcare, such as persons licensed to practice medicine and surgery, licensed dentists, professional nurses, practical nurses, podiatrists, or physician assistants. The provisions of the bill would not apply to regulatory bills proposing regulatory action with respect to those professions. Subsection B of Section 5 states that the act is not to be construed to change any requirement for an individual to hold a current private certification as a condition of licensure, and shall not require a private certification organization to grant or deny private certification to any individual. Section 6 amends the statute governing the Joint Committee to conform to the provisions of the bill. That's at page 9. This section also provides for funding of any contract to be paid from appropriations for legislative expense, also on page 9. If enacted, the bill would become effective July 1st, 2024. There is a fiscal note that was provided for this bill that the committee can take a look at. Essentially, the last paragraph of that note states that any fiscal effect really can't be determined or estimated, rather. And legislative administrative services indicated that the enactment of the bill would not have a fiscal effect on the budgets of the legislature or the legislative coordinating council, obviously, unless there was a contract. So that is what the bill does.
Thank you, Charles, for going through that a second time. The first time was a little more difficult, I guess. This one made a little more sense. Thank you for doing that. And can you tell me, are the legislators the only one that can create a new license? Or can the executive branch do that? Or can you do that through regulations?
So the executive branch could promulgate new regulations if they are within the statutory guidelines, provisions. And, that is that's always an issue, of course, between what a statute says and the regulations that are promulgated under that statute. But that, of course, ultimately is subject to determination by court if the regulation is consistent with the statute.
And so anything in this bill, does it preclude them from making a new licensure?
No, this just pertains to bills proposing either completely new regulation or strengthening regulation or increasing regulation.
Okay, and then so every year there's hundreds of bills that are introduced. Is this committee expected to go through every one of them to decide if it's a license issue or not, or is it something that just gets referred to them? Somebody notices that it might, and then it gets referred to them. I could just see it tying them up for quite a long time.
So the bill does not set forth any. The bill simply provides that the joint committee is to review and look at those bills. So certainly, persons could make the joint committee aware of proposed legislation, but the way the bill is written, currently drafted, it would be up to the joint committee to, as you said, review those bills and determine which ones.
And what happens if they miss one? Does it?
The legislation does not really specifically address that.
All right, and
I'm sorry.
No, go ahead.
I was just going to say, other than, Section 3, provides these general guidelines for the legislature to consider such bills, right? And then, so that would still be applicable. But Section 4, with respect to the joint committee, does not specifically provide any penalty or anything for not.
Okay. Committee, any questions? Representative Christy Williams.
Thank you, Mr. Chair. So speaking of new section 3 on line 33B, it says after evaluating the criteria, is that the Joint Committee of Rules and Regs, or is that the legislature? After who evaluates the criteria?
That representative, that refers to the legislature.
So after the legislature evaluates the criteria in subsection A in consideration of governmental, economic, and societal costs and benefits. That's a pretty hefty list. And is that referencing specifically maybe what's included in the report, or is that just a generalization that after we evaluate the governmental, economic, and societal costs and benefits?
Representative, so there's no actually specific direction that the legislature, I'll have to check to make sure in Section 4, but I don't believe there's any specific direction that the legislature review the report. Rather, the direction is for the legislature to consider that criteria, and the report certainly goes to those criteria.
But the report wouldn't be requested until after this step, correct?
The way Section 4 is set up, the report occurs when the joint committee reviews a proposed bill and decides that it meets the criteria for requesting a report, which is either that it's new regulation of an occupation that has not previously been regulated in Kansas, or it's stronger regulation, increased regulation.
Okay, and just for utmost clarity, then last question, understanding that, then where in the timeline does line 33 on page 3 go for the legislature? Before, after the committee of the joint committee evaluates?
So I think the intent is that the joint committee's report inform the legislature's consideration of the criteria set out in section 3. So there really isn't a specific timeline, just that the legislature shall consider those guidelines. And as far as how the joint committee's report plays into that is not distinctly specified. Other than that, of course, it would inform the legislature's consideration of those criteria.
All right, thank you.
Any further questions, Representative Probst?
Thank you, Mr. Chair. And Charles, and committee, I apologize. I'm not trying to belabor the point. I just want to make sure I understand the process of this. If as I understand this, Charles, if there's a bill that comes to is introduced in the legislature that would regulate or propose to regulate a previously unregulated industry. And in that scenario, the legislature is supposed to follow this criteria about how to determine the regulation down to the order of bonding and insurance first, then registration, then certification, then occupational license, and considering all the governmental, economic, and societal costs. I mean, it's specifying and instructing the legislature on the criteria they must use when evaluating any legislation that proposes a new rule. Do I have that part right?
Yes, that's what section 3 does, is it sets out guidelines, criteria for evaluating such a bill.
And thank you. And then that bill, supposing it passes, then goes to Joint Committee on Rules and Regs. Does it go to the regulatory agency and then to Rules and Regs? Because the way I read it, it is to be reviewed then by Rules and Reg, and there's a 12-point report that covers 12 different specific points that have to be produced.
So if you look at section 4 on page 4 of the bill, the introductory language there is, during each regular special session, joint committee shall review bills introduced in the legislature that pertain to the regulation of a profession or occupation. And then, a reference to that exception that I mentioned. And then it goes on in subsection B, upon review, the joint committee, makes that determination. Is there stronger additional regulation, or is it completely new regulation? And is it within the scope of expertise of a regulatory body or bodies? I guess I didn't mention that before. And then the joint committee notifies the regulatory body that it wants to notify, that it thinks is appropriate. And that regulatory body has to provide the report. So this is all about introduced bills.
This is not even past bills. This is just bills that have been introduced. We
Correct.
have to create this extra step of government review without even knowing that a bill is going to even get a hearing. Just at the point of bill introduction, we're going through this process and creating an expansion of government to do this review process, correct?
So within, as currently drafted, yes, there's no requirement that the bill be passed out of a committee or anything like that. Just bills introduced are reviewed, and the joint committee is then to take action based upon that review.
Okay, and then back on page 3 with the criteria that the legislature is supposed to follow, we had a little fun and conversation with this with another regulation bill previously, but this does tell the legislature that they should consider a variety of costs, including social costs and benefits. I just want to point that out. One more step I want to make sure of. So the other thing I really think is important to point out in this, so after we've introduced a bill, the legislature's told how they're going to evaluate that bill, so we kind of have some of our authority taken away. Then the Rules and Regulation Committee has to review through this criteria and do a 12-point report on every bill that's introduced, even before the legislature has determined whether it has a hearing or not. Do I have it right to this point?
Yes, as correct. There's no requirement that a hearing be scheduled or that the bill be passed out of committee or, be on general orders. Just bills as introduced are to be reviewed.
And then the next part of this is that if the Rules and Regs Committee decides that the new regulation of profession is not regulated in state and determines that there's no existing regulatory body that has the expertise, we then instruct the Rules and Regs Committee on introduced bills, not passed bills, but on introduced bills, to then contract with private, like schools or educational facilities, or basically anybody who has expertise in the field. We allow them to contract then. And I think on page 9, we give them specific authority to enter into contracts. So we're granting the Rules and Regs Committee authority to enter into contracts to produce another report that can be given to us and the regulatory body to help instruct them on how to regulate a previously unregulated industry. Do I have that part right?
Yes, I would note in addition that the contract has to be approved by the chairperson or vice chairperson of the Legislative Coordinating Council. But yes, the bill does give the Joint Committee authority to enter into that contract if it's approved.
Thank you for helping me out. I wanted to make sure I understood the process.
Or you just not introduce a bill that has licensure attached to it and save everybody a bunch of time. Representative Christy Williams.
Yeah, thank you, Mr. Chair, for one last question of clarification on page 4 in new section 4. So as we're going over and talking about this process on line 9, it says shall review bills introduced by the legislature. So the rules and regs shall review. So there's the word shall. So any of those that we were just speaking of with any licensures. But then we come to line 11 and it says there shall be no requirement for bills to be referred to the joint committee. And I just not sure if it's even, maybe it doesn't even matter because who's referring them in the first place? Or is it contradictory? Or what is the purpose of that? I guess you may not know the purpose. And then finally, the last line there in that section, the joint committee shall have authority to consider and make such determinations. So I guess the question is, all bills relevant to regulation shall be referred, but then it says there shall be no requirement for bills to be referred. And then finally, that committee decides whether or not to move forward with it. Is that correct?
Representative, I believe the intent of the legislation is that first you are correct that the joint committee is directed shall review bills introduced that pertain to regulation of a profession or occupation, with the exception that we've discussed. Now, the sentence, there shall be no requirement for bills to be referred to the joint committee for such review. The role of the joint committees in this process is to review the proposed bills, review the introduced bills, and decide basically whether a report should be prepared. So the bills do not need to be referred to that committee. The bill might go somewhere else, like, for example, this committee. But the joint committee would still be required to do that review and then decide whether or not a report should be required. So that's the distinction. And then with respect to the sentence about authority, that's just a general, sentence granting the joint committee to have with the authority to, consider those bills, make the determinations, and communicate with regulatory bodies. Because without that language authorizing the joint committee to communicate with regulatory bodies under the rules of the legislature. The committee couldn't do that. Does that answer your question?
Yes, thank you.
Committee not seeing any other questions. Thank you very much for working your way through that. We'll open up for proponent in-person testimony, and we'll start with Representative Laura Williams. So we're going to have you go through your testimony and then take questions and then introduce the person that you want to introduce.
That sounds great.
Okay.
Well, I'll answer a few of those questions as well, but thank you, committee, for bearing through that. So it is fun to be on this side of the podium, but I think as we're looking at House Bill 2818, it obviously does set up a new process, and there is a lot to this bill and a lot to understand. I also think that there are, ways that we can improve this bill. This was language that was offered as an amendment. A few committees passed that. I thank both the chairman of this committee and of Fed and State for being willing to give it a hearing. Overall, it is a very complicated and hard to follow issue. However, I do think it does kind of start the conversations of just how can we eliminate barriers for people in the workplace and giving things due process. And so I know Representative Williams and Representative Probst had, trying to follow a map. And I know our next conferees have kind of a process of that. But I do want to note that this isn't a mandatory process and happens alongside as bills are introduced. So, I heard the concerns of how does this process flow, and I do think it gives the legislature more information when examining new occupational licensing and regulation in industries, and allows, for the reporting side, if that is chosen by the Joint Committee on Rules and Regs, to be able to go and investigate the reporting side of it and being able to provide then that information on the legislature. I think as a whole, it allows for the legislature to be able to take in more information on how does licensing this new occupation or industry affect Kansans, and how does it affect health purposes and impacts in the industry and barriers to being able to get into that industry. Just a little bit of background on this legislation. So this was put forth by United We in an effort. They're based out of Kansas City to help eliminate barriers for women in the workplace. And I don't want to touch on their testimony, but similar legislation was introduced in Missouri last year, and I believe it passed. And so this was legislation. This piece of legislation then was modeled similarly to what Missouri has passed. So, as a whole, I think the goal of it is trying to give the legislature and more tools to be able to use to evaluate new licensing, hopefully being able to stop unintended consequences of new licensing issues. And I think that if it's the will of the chair to work the bill, I think that there's room to improve this bill and make it clear and more straightforward, but also not to be a burden on both the legislature and Joint Committee on Rules and Regs, but also to be able to help provide resources for the legislature to lean on when it comes to licensing industries that we may, as a body, not be as familiar with.
Representative Christy Williams.
Thank you, Mr. Chair. Representative Williams. So my question then is, why would we even need the joint rules and regs to go over it? Why couldn't we just pass a bill that said you have to have this report prepared if you're going to, if a regulatory board wants to expand any of their regulations or add a new certification, that they have to they have to submit this, or we're not going to hear their legislation? Why not do that?
I think that's a good point. I do think that even how the bill is written currently and how do we go about, deciding which bills that are introduced that we review and we don't review. I think that is something to consider. And that's pretty much my feedback on that.
Would that work to just eliminate all of those steps and just require regulatory boards to have a report submitted to the legislature in the event that they want to expand regulatory authority or expand licensure? Would that work is really what I'm getting at.
I think the report in and of itself helps the legislature bring a better perspective on how this impacts Kansas. So I don't know the implications of making that mandatory and if that's legal within the realms of the regulatory process. I think that would be a conversation that we need to continue to have.
One last question, if I may. Would that be any different than having the joint rules and regs make the same kind of requirement that you must produce a report? If we're going to have the Joint Committee of Rules and Regs require a report, wouldn't we want to just preempt that and say, hey, don't even bother because we're going to need this up front? Wouldn't that save a lot of time and also potentially do the same thing in terms of it's required by the legislature or it's required by the legislature? Either way, you're required by the legislature.
Yeah. At this point, and the way that this bill is written, is not required. And so it provides an avenue for it to be able to be there. But, talking about a mandatory requirement, I've never had that conversation before. And I think that's something that we can think about if the legality of that option is there.
Good point. Thank you.
Representative Dodson.
Thanks, Mr. Chair. Maybe this is best for, and I apologize being out of order here, but for Charles, perhaps. Don't we have a process for the promulgation of regulation? In other words, they just come out one day and hand these things out, or is there a hearing process like we have in the federal government? And then is there a process for redress? That is, when a regulation is promulgated, doesn't any of the professions have the opportunity to come back and say, this is going to be too hard for the following reasons?
Charles.
Representative, yes, there is a process in statute that requires the agency to have proposed regulations, have hearings, and also have those regulations run through the Attorney General, the Director of the Budget, and I think also the Secretary of State. Thank you. So there is a process in place for regulations to be adopted, and as Representative May recall, there is legislation to sort of alter that process that we heard in this committee. So let's see. So this, I'm sorry, I'm forgetting the second part of your question.
Is there a process for redress if a particular profession feels that something's too onerous? Can they request a hearing?
Well, yes, the agency could come before the legislature and propose legislation. And of course, there's always the possibility of a lawsuit if someone is unhappy and that, with a bill, with a statute rather. So does that answer your question, Representative?
Yeah, but I had thought there was also a process for them going back to the agency that was providing the regulations to seek a hearing with them.
Yes, certainly. I think most agencies have a procedure where if they enter an order against a person, an individual, there's an appeal process. And a lot of those appeals are handled by the Secretary of Administration, but some are within the agency itself. Does that answer your question?
Yes, thank you very much.
Representative Probst.
Thank you, Mr. Chair. Thank you, Representative Williams. There's a couple of definitions, and I will probably save most of these for other conferees. But on page 3, line 39, there's kind of a phrase that to me seems to be the linchpin of this first part of this that says, if the threat to the general welfare resulting from the practitioner's services is easily predictable, the regulation shall implement a system of insurance bonding registration. Goes on. I have a couple of questions, and maybe further conferees will address this, but I'm curious about what sort of things we're looking at when we talk about unregulated industry or previously unregulated industry. And then I have a question generally about, the idea is that unless we have a real compelling reason to regulate or create some regulation around this unregulated industry, then we're not going to. And we've outlined what I think is an overly complicated and burdensome process to do so. But where's the line? I mean, how do we determine that regulation is needed? If we're going to assume no regulation until we cross a threshold, what is that threshold?
I mean, I think when we're looking at, regulating new industries that are not regulated currently, we're tapping into industries that are growing and changing, and we're bringing in jobs. I mean, as a woman, I think of the Board of Cosmetology and things that fall underneath that. That industry in and of itself is changing, and there, are a lot of new skills and procedures that are, taking place that are new every year. So I think, as we're looking at the bill, spray tanning, for instance, what happens if that now is deemed something that wants to be licensed? How can we be able to protect the people in that industry from new licensing requirements and giving them time to, one, be able to allow for the legislature to review the seriousness and impact that would have on Kansans to regulate both on the consumer side and on the workforce side. But it's just providing more resources and more time in industries that are ever changing.
So, Representative, you're a pretty astute representative, and I know you have a firm grasp on all the bills that are being introduced around here. How many bills this year would this affect?
I have, not to my recollection, that I could recall that number.
Okay. Any further questions?
I will say, and I don't know, the elevator bill. I don't know, how would this be able to, bringing in more information that we can be able to compile? What could we have stopped from, down the road? It just brings up, how can we be able to supply us more resources so we don't have, things that we need to fix later on?
I think you're correct. If this was in place when we decided to license mechanics for elevators 2 years ago and causing all this debacle that's going on, probably would have stopped it. Thank you. And I'm seeing no further questions. You want to go ahead and introduce your conferee?
Thank you, Mr. Chair. And I do want to introduce Joan Ruff from United We. She's the chairwoman of their board, and she's here to testify on this piece of legislation and work that they've been doing when it concerns regulations throughout the state of Kansas and the impact on women.
All right, come on forward. Welcome to Commerce Committee.
Thank you. Good afternoon, Mr. Chairman and members of the committee. It is a pleasure to be here, and it is an honor to be the chair of the board of United We. United We was started approximately 30 years ago by visionaries who recognized the importance of women to the economy and to family stability. And they recognized that they needed some special research, some special looking at who they are and how do we make sure that they are able to contribute their best to the state of Kansas and throughout the Midwest. We now do our work, and our mission is women's economic empowerment and civic engagement. As an organization, we establish our policy provisions, our policies based upon research. We research the status of women throughout various states. We have done an extensive status of women research in the state of Kansas, working with the University of Kansas. We have held up many, many town hall meetings throughout Kansas and talked to hundreds of women. We ask about where they are, how they want to, what they need for entrepreneurship or professions, et cetera, et cetera. Through this status of women, one of the greatest things that has come out is that women are much more likely, about 10 to 15% more likely to have professions that require licensing, or they are in, as was talked about earlier, those emerging types of occupations that are not yet licensed, but want to make sure that they are, in fact, able to have their livelihood without being interrupted by unnecessary government regulation. So towards that, we have also done similar studies in Missouri, Oklahoma, and we're doing studies in Indiana, et cetera. And they all come with the same, the same analysis. So as a result, we are very, very encouraging the committee to enact the intent of House Bill 2818. The fact is that with women fully participating in the economy, that Kansas could grow 10 to 15 to 20% over the next 5 years. So I think we need to look at licensing as a critical component of how we make sure that women and their families are able to earn and practice their profession with the least government interference. One of the other types of professions that might be affected as we think about what isn't currently regulated, but is really hot right now, pet grooming, for example. Women are doing more and more pet grooming, and it is becoming a burgeoning industry. We also have women who are looking at farmers markets. They are currently unregulated if you're going to a farmer's market. The important thing is that for women to be out there and to be able to not only support themselves and to support their families, they need to be able to have the ability to work in their profession with the least government regulation. So we do support this regulation, this bill, and the intent behind it. Any questions that I might answer?
Representative Clayton.
Thank you, Mr. Chair. Thank you for being here. So the previous speaker mentioned that a similar bill to this model legislation passed in Missouri. How recently was that?
I believe it was 3 years ago.
All right. So do we have hard evidence from Missouri that this has actually empowered women economically?
I cannot say from my own standpoint what evidence we have. I will certainly look at that and get back with the committee on that. I do know that there are 14 other states that have also enacted similar types of occupational licensing sunrise provisions.
Do we
And
have
those-
information from any of those states?
And these are the states that have done it. The Council of State Governments has identified these 14 states. You may not want me to read it off.
Oh, no, it's fine. I can look it up on CSG. Do we know what kind of results this legislation has brought?
Most of this legislation is relatively recent.
Okay.
So there's not a wealth of historical data on that. Again, we at United We are following that closely.
Thank you.
Any other questions?
I'm seeing none. Thank you very much.
Thank you very much.
Next up, we have Andrew Wines on behalf of Opportunity Solutions. I know I calling that on purpose.
Mr. Chairman, members of the committee, my name is Andrew Wines. This room makes me forget how to pronounce my last name sometimes. Now, thanks for the opportunity to testify in support of this bill today. I'm going to not read my testimony. I think you all have asked a lot of questions, and they're good questions. And hopefully the proponents and opponents and neutrals, whoever, can get together and streamline the bill if it needs to be done. But I do want to talk about some of the things that we think this bill does that are positive. We think it promotes economic freedom. It establishes some guidelines for legislative consideration of new regulations that ensures individuals have the freedom to pursue their chosen occupations without unnecessary intervention by the government. It protects consumer choice. As mentioned previously, it prioritizes the least restrictive form of regulation, such as bonding or insurance, which provide consumer protection, but still allow for greater choice and competition in the marketplace. I think it prevents barriers to entry. We all know licensing creates a barrier to entry for someone who works in that profession. And sometimes there's good reasons for that, but we think you should have good information before you establish another barrier to entry. And then it focuses on public interest, ensures that regulations are enacted for the public interest rather than for arbitrary reasons. Encourages self-regulation. There are some regulations, some occupations that have a good self-regulation mechanism, maybe an industry-led initiative that can be effective in maintaining standards without having the government create a licensing regime. And then it ensures transparent decision-making. I do think this bill does establish an additional step, or grows government, if you will. But we have processes in place like a fiscal note that you all probably value and benefit from in the legislating process. And then others could talk more about this, but a supplemental note, I mean, that requires staff and it grows government, but it gives you the tools you need to make good decisions. So with that, I'm happy to stand for questions and support this bill. Thank you.
Committee, any questions? Representative Probst.
Thank you. And thank you, Mr. Wines, for being here.
You're welcome.
I had mentioned before that I have some questions about the definitions, and I'm curious about general welfare. And I'm guessing that you and I might have a different definition of what general welfare means. So do we feel in this bill that we're going to, when we try to define something like that, that we're going to be able to, I guess, make any progress on that? Or there's 225 in the House and 40 in the Senate. We all have a slightly different idea of what general welfare means.
Yeah, no, that's fair. I think this general welfare definition is very general, which, it is what it is, I suppose. I think the bill attempts to set forth definitions that make sense with the process in this legislation. Obviously, in different contexts, it might, have kind of different shades of meaning. So I don't know if that helped answer your question, but it's a fair point.
And I do have one more question. I'll take it easy today.
Thank you.
You're in the building a lot. The point of the idea of, do we get a lot of bills for licensing? I just don't see that we're dealing with that a lot. And certainly the makeup of this body doesn't feel to me inclined to regulate or license every occupation under the sun. It quite feels the opposite to me.
Yeah. Good question. Nice glasses, by the way, Representative. I do think, I don't know how many bills were introduced this year or even in the last, in this biennium that regulate a new occupation or add regulations to an already regulated occupation. And I do think that this body generally has kind of a good finger on the pulse for what the factors are at play. But this process does put in place some, additional information gathering tools that can maybe help you all make a more informed decision. So now, could that be cleaned up to the previous representative's question, and maybe instead of referring to a specific committee, it goes to the full legislature, or you wait until there's another threshold before the report gets drafted? I think those are, reasonable suggestions, and that process could probably be streamlined a little bit.
Along those lines, though, to that point, couldn't we accomplish that through the normal hearing process? Do we need to expand this to have a criteria that the legislature reviews and it has all this laid out that we have to follow, then have it go automatically, every introduced bill, to a review body that then produces another report that then, if they don't have the resources, they can contract? I just feel like if there's a bill to talk about licensing, we have a hearing process, and you and all the proponents on this bill are free to come tell us why licensing something would be bad.
Yeah.
And then we can make that decision. I feel like, am I wrong in thinking that this is adding a lot of unnecessary steps that we could just handle in the hearing process?
Yeah, thanks, Representative. Mr. Chairman, I do think that a sunrise review is another step in the process. I think it's a helpful procedural safeguard to prevent overregulation or to prevent the construction of new barriers to, prevent the construction of barriers to opportunity. But you're right, the legislative process is a good one. I've said that a few times this session. I know other lobbyists have as well, that there's a reason we have hearings on bills and discuss them and go through the amendment process. It's usually pretty good at kind of ferreting out what the right thing to do is. But I do think this is a value add, and it probably could be cleaned up. The language probably could be cleaned up a little bit, but I do think it could provide some information that might be tough to get at in a hearing as it relates to the study and the report. I mean, there are a lot of provisions in this report that could be helpful, and some of them, to your point, you might find out in the hearing. So, thank you.
All right, seeing no further questions, thank you very much for coming in. Next up, Elizabeth Patton, Americans for Prosperity. Welcome back to
Hello.
committee.
Thank you, Chairman, for the opportunity to testify in front of committee. My name is Elizabeth Patton, and I'm the State Director for Americans for Prosperity, Kansas. I do want to start off by saying I tried to kill the elevator bill. So anyway, apologies. I just had to mention that.
You'll have your opportunity next week.
I'm here for it. I'm all in. I did want to address a couple of things. You guys have my written testimony, but I did want to address the concept of sunrise bills such as this one. We support this legislation. We actually see this type of process in about 22 other states, and they go back as far as 1985, 1977. Like, a lot of these have been in place for many, many years. We are one of a few of the states that really don't have any on the books. And our point with that is that if done well, this sunrise bill can give the legislature an extra tool in their toolbox to make sure that we are being careful, especially with the occupational licenses, which are often brought to committees by the sometimes even by the occupation themselves, but in fact, they have a pretty devastating economic impact, especially on low to moderate income individuals. And we want to help empower everyone to achieve the American dream. I will say first, I do have an amendment that I have shared with some of the other coalition partners on this that we would like to see tightened up, especially in related to the language around general welfare and a lot of pieces in section 3 and 4. So assuming that they would be willing to continue that conversation with me, I do think there are some places where we can tighten that language to make it a little bit more clear and precise and consistent with bills such as what passed a few years ago related to our occupational licensing reciprocity law from, that was probably 2021. So I do have some thoughts related to that, but I did want to point out that actually about 30% of our occupational licenses in Kansas were enacted between the years of 1993 and 2012. And we have had several, even in the years since then, much to probably my own chagrin. And by a quick read of my legislative tracking software, I think there were a little over 10 that were introduced for this session alone. And then there were an additional 5 introduced that actually reduced or improved the regulatory environment for licenses, but about 10 that would have increased those fairly egregiously at varying stages in the process. So I just wanted to point those things out. We think that processes such as this actually end up being very common sense, and they really do help provide I don't think about it as growing government as much as asking government to really do their job, frankly, and take an extra look at the laws that are being enacted that affect people's everyday lives. And those often come with second and third order consequences. And when we're talking about the ability for our economy and people's livelihoods, especially with low to moderate income, we need to have processes in place to make sure we are not unintentionally making entrepreneurship or achieving the American dream, changing careers, more difficult than it should be. And with that, I'd be happy to stand for questions.
Representative Chrissy Williams.
Thank
Thank you, Mr. Chair. As we continue on this discussion, I'm thinking about, for example, there was a sugaring bill
Yeah.
that was introduced, and that sugaring bill related to the Board of Cosmetology that was trying to create some regulation over something that isn't regulated. So, but I don't think they were requiring a licensure. How would this handle those types of activities in which those agents or those boards are creating regulations without us?
So, couple things. I am hopeful. I would like very much to make certain that things like that, I would love to get to that point, honestly, and make sure that we do not have those types of things going into law that don't make sense. And I think to that point, this is one piece of the pie. Is this the silver bullet to fix all the occupational licensing issues in Kansas? No. Just like the bill we had a couple of years ago, like these are steps in the right direction as we put this puzzle together. Because you're right, like we do have an enabling clause for the Board of Cosmetology that created the sugaring issue, and in fact, that's a problem. We hope that bill continues and eventually gets signed by the governor. We think it's important that it impacts people's livelihood. So I would say I would love to see something that addressed that even more than what it is. I think the issue we continue to run up against is actually the Stephan Supreme Court case and the ability for the legislature to have a little bit more oversight in that way to prevent things like that from coming on in the first place. So candidly, my opinion is that we still need a constitutional amendment to reset that balance of power.
Thank you.
All right, seeing no further questions, we're going to go ahead and move on to the opponent section. And I think we only have one. Mr. Carnes, are you here? Okay, we have another bill that we're getting to here shortly. I read through your testimony. It seems like a lot of these questions kind of go to your testimony. So if you can touch on that, thanks.
I'll be very brief. First of all, I appreciate the opportunity to appear before you, and I appear before you today without my walker. Last time I was here, I was a little incapacitated. Anyway, I am the executive director of the Kansas Board of Technical Professions. We license engineers, architects, geologists, land surveyors, and landscape architects. So I'm one of these agencies that issues the regulations that you're concerned about. I want to talk with you a little bit about some fundamentals. The only way my agency is able to issue a regulation for engineers or architects is because the Kansas legislature passed a practice act which gave us authority to regulate those professions. I can't regulate, for example, interior designers. They're not part of my practice act. So I can't expand my regulations to that group of people that aren't currently regulated. This law talks about two different things. New professions that are going to be regulated in the future. The only way those new professions can be regulated in the future is if the legislature passes a practice act that enables some regulatory body to regulate them. So you've got the first step in this process. But it also goes further than that. It says any increase on regulation of existing professions would go through this process as well. That touches on the people that I regulate. Now, I've got a board of 13 people. They're subject matter experts. They're created by the legislature, the makeup of that board. I've got 3 architects, 3 engineers, people from those professions. And they tell us what's appropriate or not appropriate for the regulation of those professions so we protect the health, safety, and welfare of the public. We take very seriously our charge to only protect the health, safety, and welfare of the public. When we go through the legislative process, we vet it over and over again in our committee meetings with my board before we ever present it to the Attorney General, the Budget, or the Department of Administration for their comments and go to the Joint Committee on Rules and Regulations. We try to be very narrow with what we do and only enact regulations that are necessary for protection of the public interest. What I'm concerned about, and it's been pointed out here many times, I'm a lawyer. I practiced law for nearly 4 decades in the city of Topeka. After that, I was the director of the Workers' Compensation Division of the Department of Labor. I was part of the Republican administration running that agency. I've generally been very favorable for business all my life. I'm concerned, though, that regulations that are necessary to protect the health, safety, and public welfare will be impeded by definitions in a statute that are so vague that they can't be enforced. How do you know what the least effective regulation is? Well, there are terms in this bill such as substantial burden, least restrictive type of occupational regulation, whether or not the regulation practice could cause harm, the most efficient form of regulation. And the statute says the legislature will determine the most efficient form of regulation, and that's what they shall enact. That's a very tough burden to decide what that would be. I think we could all argue what is or what isn't the standard to determine what's the most efficient way of regulating something. Now, as a regulator, I'm here to stand for questions. I don't know that I'm personally a subject matter expert, but I'm happy to address anything you'd like to ask.
I would point out, though, that this bill doesn't affect your agency. It only pertains to bills being introduced. And so.
But the bills turn into laws, and laws turn into effect
Sure.
on our Practice Act.
Any questions? Seeing no questions, thank you. Anyone else here to testify on the bill? Seeing none, we'll go ahead and close the hearing on HB 2818 and open the hearing on HB 2820. And we'll get a brief overview of what the bill does. Supervisor Hamilton.
Thank you, Mr. Chairman, members of the committee. For all of you who were here last week for our hearing on 2766, you'll notice that some of the key definitions in this bill are similar or identical to the ones in that bill. Again, we're talking about foreign principles, and again, that term is restricted by the term country of concern. So People's Republic of China, Cuba, Iran, North Korea, Russia, Venezuela. I'll go through the substantive provisions and then go back over a few new key definitions. So Section 1A would state that in addition to any applicable statutes concerning purchases, a governmental agency shall not purchase, acquire, or otherwise use any drone or any related services or equipment, the critical components of which were 1, produced in any country of concern, or 2, produced or owned by any foreign principal. Under subsection B, any such drone components, services, or equipment acquired before July 1, 2024 could still be used by a governmental agency until July 1, 2029. If such agency determines that a component needs to be replaced, it could use a replacement component acquired prior to July 1, 2024, but no new replacement component could be acquired from a foreign principal. Subsection C contains exception language and states that any acquisition otherwise prohibited under subsection A or B may be completed by a governmental agency if 1, there's no other reasonable means to acquire such critical components or of addressing the needs of the governmental agency necessitating such acquisition. 2, the agreement for such acquisition is approved by the Secretary of Administration after consultation with the Adjutant General. And 3, failure to acquire such critical components or otherwise address the needs of governmental agency would pose a greater threat to the safety and security of the state than that posed by entering into such acquisition agreement. So going into the definition section, governmental agency means the state or any political or taxing subdivision of the state or any office, agency, or instrumentality thereof. Drone would mean an unmanned aircraft, watercraft, or ground vehicle or robotic device that is controlled remotely by a human operator or operates autonomously through computer software or other programming. And then critical component, this term in particular, I think is sort of the core definition of the bill, because we aren't necessarily just talking about, we're not talking about drones, we're talking about drones with a critical component. And that's defined with those components or subcomponents that are A, distinct and serviceable articles, and B, the primary component or subcomponent of an identifiable process or subprocess necessary to the recording, storing, or transmitting of data or any other form of information. So in other words, the drone has to have this sort of data transferring component to it to fall underneath the restriction of the bill. The way I was thinking about it is that, at least the way that I read this language currently, is that the state could acquire a drone from a country of concern if it does not have a critical component as defined in this bill. But inversely, the state could be prohibited from acquiring a drone from, say, Germany or any other country that's not of concern if it has a critical component that was created or owned by a country of concern. So that's the main piece. Does it have a critical component, the data transferring technology? The bill would become effective upon publication in the statute book. And with that, I'd be happy to take any preliminary questions.
Committee, any preliminary questions? Representative Laura Williams.
Thank you, Mr. Chair, and thank you, Kyle, for that. Okay, I have a scenario in my head, and I just wanted to see if it falls within this bill. So say a state agency contracts out a company to do work that utilizes these drones from the countries of concerns. Is that allowed in this bill?
If the company is using drones that have a critical component that is created or produced or owned by a country of concern, that would be prohibited. And it would likely be the case that this requirement would be part of any procurement contract that the state is issuing for those drones.
So then then I'm going to take it a step further. So say then that company hires an independent contractor, 1099, and are they still to follow that contract as well? Or would this bill not be applicable to them?
So to any extent that the governmental agency is using or acquiring or purchasing the drones that fall underneath the restriction, it would be prohibited.
So then is this monitored then by the procurement piece of it, of how would state agencies and these contracts be followed to make sure that they're following this piece of legislation?
From what I understand, it really would be incumbent on the procurement division to ensure that these requirements are part of all the state contracts and followed accordingly.
Okay, great. Thank you.
Representative Blue.
Thank you, Mr. Chair. Kyle, this is way over my head, so I'm trying to fully understand. I do know that there are current government agencies that utilize drones as we speak. If this bill were to go into law, how would that affect them? Do they have to turn them all over? Are we getting new? How does this work? Yeah, how does that work?
So if that governmental agency had acquired basically a restricted drone that has one of those critical components before July 1, 2024, they could still use that until July 1, 2029. The bill doesn't expressly state that they have to divest themselves, but at that point, they wouldn't be allowed to use it. And so if they have already acquired that restricted drone and they need a replacement component, they couldn't get a new replacement component from a foreign principal.
So on July 2nd, 2029, does this bill just not go into effect anymore? Or then they would have to turn over their drone that if it had any of that you're just talking about?
Closer to the latter scenario, because they have until July 1, 2029 to still use those prior acquired drones, but past that date, then they wouldn't be authorized to.
Okay, thank you.
Seeing no further questions, I would also like to welcome Representative or Leader Croft to the meeting today. He doesn't have voting privileges, but he is here for questions. Did you have anything to add to that, sir?
To just in general, Mr. Chair. So generally, I mean, is exactly what you guys are saying. We added the 5-year window in this process to just make sure as we go through it, that it was a reasonable amount of time, how these drones, their life expectancy, and then we go through and replace some of that. I think in here, as you pointed out, that there's a concern about replacement parts through this process, and it may not have been clear. If we need to make it more clear, I'm absolutely willing to make it more clear, because they still have to operate. You can't expect them to not have replacement parts over the next 5 years. And the real intent in this, as we were talking earlier, is the fact that, while we're going through this process and we're ramping up our manufacturing, we can't expect everybody at the same time to buy it all and expect them to show up. And I don't want to shut down the process. So that's why we gave a 5-year window as well. So thank you, Mr. Chair.
All right, seeing no further questions, thank you very much. All right, committee, we're going to go to our first proponent in person. I believe they're on WebEx. And I'll point out, I think we have 3 conferees and we have about 15 minutes to get through this at the most. And so hopefully we can hit the high points. We'll start with Brian Kavanaugh, Senior VP, American Global Strategies, and I believe he's via WebEx. Nope. Okay, we'll move him to written only for now, unless we can get him to chime in. Michael Lucci is also on WebEx, I understand. State Armor Action.
Thank you, Mr. Chairman. And
hey, welcome
thank
back to committee. I'm sorry you're not in person. We miss you.
Well, it's always great to be with you all in Kansas, but thank you for having me on WebEx, and thank you, members of the committee. My name is Michael Lucci. I'm the founder and CEO of State Armor Action, and I've had the pleasure of speaking with you all before, but let me go through quickly, I think, some high-level points about why this is important legislation. First, the drone technology is critical for state and local government, and it'll probably become more important over time. Furthermore, it very obviously now has significant military application, and that speaks to the importance of ensuring that we have this capacity within the United States to produce such drones. 2 priorities of State Armor are to build supply chains of freedom, as we say, like buying and building with free and allied nations, but also to protect critical infrastructure. There are a couple strategies that we want to oppose that are perpetuated by the Chinese Communist Party. One's called the military civil fusion strategy. And what that is they want to dominate any technology that has both civilian and military use. Drones, exactly that, as we see in Ukraine and elsewhere. The drones are very important military technologies. They also have kind of a dual circulation strategy, which we're seeing. And what that means is they want to indigenize these technologies within their country and have the rest of the world be dependent upon them. I can't speak to Kansas, but I do know that we recently worked in Arizona. 95% of the drones used by governments in Arizona are from one company that's actually defined by the Department of Defense as a Chinese military company operating within the United States. That's my next point. There's a list called the 1260H list put out by the Department of Defense. It's updated maybe 1 or 2 times per year. And DJI, which is a manufacturer of drones based in China, is considered by our Department of Defense to be a Chinese military company operating within the United States. Next, DJI, which is the major provider probably everywhere, has been sanctioned by our Department of Treasury for human rights abuses, for their involvement in human rights abuses in the Xinjiang region. That occurred December 2021, is what our Treasury Department sanctioned them. A Uyghur human rights report said that just came out last week, said DJI is complicit in crimes against humanity. If you buy or sell DJI products, you're dealing with a Chinese company that's profiting from massive human rights atrocities. Finally, according to America's Cybersecurity and Infrastructure Security Agency, these drones pose an espionage risk. To quote one of their recent reports, Chinese manufactured drones continue to pose a significant risk to critical infrastructure and U.S. national security. While any drones have vulnerabilities to enable data theft or facilitate network compromises, PRC has enacted laws to provide the government with expanded legal grounds for accessing and controlling data from any firm in China, which of course DJI is one of those firms. With that, in conclusion, we think that this is a great step to kind of phase in drone supply chains from free and allied countries, America first and foremost, and to comfortably phase out dependence on drones from adversary countries. Thank you.
Thank you, sir. Any questions? Seeing none. Thank you very much for being here today, or not being here today. Thanks for not being here, sir. All right, we'll move on. Is there anyone else here to testify in person as a proponent? All right, seeing none. I don't have any opponents listed. Is there anyone here as an opponent? Seeing none, I do have a neutral in person, and that would be Chief Darrell Atberry. Coming up, sir. Thanks for being here with us today.
I am testifying on behalf of the Kansas Association of Chiefs of Police, the Kansas Sheriff's Association, and the Kansas Peace Officers Association. And our testimony today is neutral. Our associations understand the need to address the activities of adversarial countries in the United States and the potential use of technology produced in those countries to potentially use the information from that technology against our country. And we appreciate those facts. We don't think that the equipment that we use rises to the level of being a great concern, but we understand the purpose behind the bill. We estimate there are about 200 to 250 agencies across the state of Kansas, probably closer to 250 that use drones today. Most of those, about 90%, kind of like Arizona, are DJI drones. They range anywhere based on their capabilities between $12,000 and $35,000 per unit. Our members tell us that there are two main reasons why they use the DJI drones, and one of those is the lower cost, especially those when compared to those made in the United States. And then the quality of the video that comes from those videos from the drones is better. I spoke with Major Heffley here from the Lawrence Police Department, and he said he recently saw that as fact. So the drones enhance public safety and officer safety. We're able to watch from a distance, identify suspects, sometimes search homes because there are some very small drones that have that capability. And it makes our job safer, and it helps us enhance the safety of our communities. So while we understand that bringing the bill forward is a good thing, we still have some concerns. Before I get to those, I just want to hit on the positive things that we have seen in this bill. And these are found in Section 1, subsection B and C. And that is the prohibition to use of existing drones is not immediate. We like that 2029 timeframe. The time provided to plan and budget for replacements is there also, that 2029 timeframe. The path to support continued and the continued use of the drones also there. And the definitions give us clarity as to what we can do and what we can't do. And we also appreciate that. However, our neutral position is based on our concerns that our membership has expressed to us. And one is that it, as it currently is written, is an unfunded mandate. We have a lot of departments in this state that are very small, and trying to acquire that expensive piece of equipment that is useful for the safety and welfare of our communities, it's just expensive. So that also comes on the heels of an FBI mandate that we handle our encryption of our radios, and that's been very expensive for us too, and that's happening right now. So this is running side by side with that. The other is the increased purchase cost. That can be 25% to sometimes 100% based on the company that you go with, whether it's an outright purchase or purchased as a service that has ongoing life and costs more over time. The replacement before end of life, we're concerned about that. I've got one in my department and it's fairly new. So I will replace it as quickly as I can. But again, we like that 2025 or 2029 timeframe. And then the quality of the video, that's a concern. So those are some of our concerns, but we also want to advance some thoughts to you on some amendment recommendations. And that is to provide state funding to pay the cost of purchasing replacement devices that comply with the restrictions. This is something that Missouri did in House Bill 1415. And that seems like a good, reasonable idea for us, for the state to help us replace these drones as quickly as we can. And we can do that if it's funded, possibly through the state. The other thing is to direct a state agency to assist in assuring that the devices offered for sale comply with the new law. And we do things like that, and to develop a bid process. Those two things together are things that the state does right now. My police cars I got on state contract. DUI testing equipment, we get on state contract. They're your computers. You get on a state contract. It's something that's already done, and we could possibly add this to that group that does that vetting, so that we ensure that we're buying equipment that follows the intention of this bill. And with that, I'll stand for questions.
Okay, well, thanks for bringing your concerns today. Some of your concerns were my concerns, and I was wondering about a way to try to find funding in order to speed up the process. Do you know the drones that are currently out there that are the DJI, can they be retrofitted to avoid having to replace, or do we have to replace the drone entirely?
I think they're full component integrated pieces that you can't piecemeal together. I think that if you changed operating systems with the drone, you've got to do it wholesale.
All right, so you said there's 200 to 250 departments that have drones. Would they have just one drone like that, or would they have several?
It depends on the department. I have one drone. I know Wichita PD has many drones. The sheriff's office has a number of drones, and they range, like I said, from that $12,000 small unit, which can't take the wind very well, and we're here in Kansas, to those larger drones that can withstand the wind to go up and do missions.
And 90% of them are the DJI drones. Okay, Representative Sutton.
Thank you, Mr. Chair. I just want to clarify, make sure that I understood what you were saying in your testimony regarding the funding necessary. I understand that the domestic drones are 25% more expensive than the JGI?
DJI.
DJI, okay. Is that correct?
They're about, we've estimated about 25% to 100%, depending on the drone that you're looking at. The DJI Avata is $1,750, but I think if I understand correctly, they sell that and as a service, and that's one that would fly into a building and check the interior of the building. You have drones like ours in my department that can go up to about a 20-mile-an-hour wind, but it's got night vision, and we're able to see suspects and guns and things that have been discarded with that. But then you also have larger drones that are able to stay up in greater wind. They have greater capabilities. Their cameras can see further. They might have, depending on the drone, a GPS component that they're able to map out a scene from the sky and then translate that into something we can use during our investigations.
Or the point I was wanting to get to on that is that what you would really require would be the delta funding between the domestic and the Chinese or DJI cost. Is that, am I understanding you correctly?
To get funding today from you, I would go out tomorrow and purchase a domestic, well, maybe next week. But I would get a domestic made drone to further this bill. But if I have to do it in my budget cycle somehow with no assistance, it's going to take quite a while.
All right. Thank you.
All right, we have time for the 2 more questions. Looks like taxation is here, so we've got to get out of here. Representative Shu.
Thank you, Mr. Chair. I hear you on the unfunded mandate part. That part sounds like it's in discussion and probably fairly easily fixable. Kind of said in your testimony as well, it sounds like the Chinese drones are currently a better product than is available otherwise. Is that true? Is that a concern? Or is it just they are a better product for a cheaper price, and so we would just have to pay an extra premium for domestic products?
Well, it's what I've heard is anecdotal, but it's from a number of sources. So the DJI is a good product for use. It just has this issue. If it did not have this issue, that would be my drone of choice. But it has this issue that it's tied to the Chinese government, and that's a negative. It's a big negative.
Okay. Yeah, I think that's something for us to try to figure out because, I think we've all seen pixelated videos and if you guys are trying to locate a missing persons, even if it's a little bit more pixelated, that we could miss people. So that's something we gotta think about. Thanks.
Representative Osmer.
Thank you, Mr. Chair. Thank you very much for your testimony. It actually put into context quite a lot of things that I was trying to figure out. I know you can't speak for the entirety of the state of Kansas, but at least for your departments to be able to determine things. I wanted to know, I think you have answered a lot of these questions, but do you typically buy them from a Chinese market for a drone itself, or where do you typically source drones from?
There are a lot of domestic companies that are the distributors here in the United States. And for instance, our department, I think most departments work through those stateside distributors to acquire the drones.
Okay. And what is the typical lifespan of a drone?
The exact answer is that depends. Some of them, well, as good as a pilot is, sometimes they crash. So then it's, of course, very short. But I think if it's taken care of, it's much like your car. You attend to the maintenance of the equipment, you care for it, and it'll last longer. So I'm estimating, 5-6 years.
Okay. All right. Thank you very much.
But that 5 to 6 years is just a guess on my part.
Understand.
Yeah.
Thank you.
Okay, that's all we have time for, and I'm not saying any more anyway. Thank you so much for coming. Thanks for airing your concerns, and hopefully we can address most of them when we work this bill tomorrow. I think we're going to plan on working this bill tomorrow along with the other one. Representative Croft, do you have anything to add?
Mr. Chair, thank you. And I appreciate everybody coming to the table talking. Agreed. We have some definition problems that we think we're going to have to work through, but I appreciate that. And I do acknowledge that maybe sometimes we look at and think we don't have as good a technology. I think the technology is the same. It's a matter of availability too. So there's both of those things we have to consider in this process. So again, with that, I look forward to anybody. If you have some recommendations, come see me. I owe the chairman something by tomorrow. Thank you, sir.
Thank you.
And we are adjourned until tomorrow.